Okay, searching juveniles in school, New Jersey versus T.L.O. Justice for the opinion of the court. We grant certiorari in this case to examine the appropriateness of the exclusionary rule as a remedy for searches carried out in violation of the Fourth Amendment by public school authorities. Our consideration of the proper application of the Fourth Amendment to our public schools, however, has led us to conclude that the search that gave rise to the case now before us did not violate the Fourth Amendment. And accordingly, we here address only the questions of the proper standard for assessing the legality of searches conducted in public school officials and in the application of that standard to the facts of this case. On March 7th, 1980, a teacher at Piscataway High School in Middlesex County, New Jersey, discovered two girls smoking in the lavatory. T.L.O. One of the two girls was a 14-year-old high school freshman. Smoking in the lavatory violated a school rule, and the teacher took the two girls to the principal's office. Assistant Vice Principal Theodore Choplik questioned them, and T.L.O.'s companion admitted that she had violated the rule. T.L.O., however, denied that she had smoked in the lavatory and claimed that she did not smoke at all. Choplik asked T.L.O. to come into his private office and demanded to see her purse. He opened her purse, found a pack of cigarettes, which he removed from the purse and held the cigarettes in front of her and confronted her for lying to him. As he reached the purse for cigarettes, Choplik also noticed a package of cigarette rolling papers. In his experience, Choplik associated possession of rolling papers with the use of marijuana. He suspected that a closer examination of the purse might further yield evidence of drug use, and he searched the purse thoroughly. The search revealed a small amount of marijuana, a pipe, a number of empty plastic bags, a substantial quantity of money in $1 bills, an index card that appeared to list students who owed T.L.O. money, and two letters that implicated T.L.O. in marijuana. Oh my God. Okay. Wow. Choplik notified T.L.O.'s mother and the police and turned the evidence over to the police. At the request of the police, T.L.O.'s mother took her daughter to police headquarters, where T.L.O. confessed that she had been selling marijuana at the high school. The state brought delinquency charges against T.L.O. based on the confessions and evidence seized by Choplik. T.L.O. contended that Choplik's she was suspended for 3 days from school for possession. Okay, Choplik's search of her purse violated the Fourth Amendment, moved to suppress the evidence he found and her confession, which the allegedly unlawful search also tainted. The juvenile court denied the motion to suppress. The court concluded that Choplik conducted a reasonable search. His initial decision to open the purse was justified by his well-founded suspicion that T.L.O. had violated the rule forbidding smoking in the lavatory. Once he opened the purse, he saw evidence of marijuana violations in plain view, which justified a thorough search to determine the nature and extent of T.L.O.'s drug-related activities. The juvenile court denied T.L.O.'s motion to suppress, found her delinquent, and sentenced her to a year's probation. T.L.O. appealed the Fourth Amendment ruling, and the Supreme Court of New Jersey reversed the judgment of the appellate division and ordered the suppression of the evidence found in T.L.O.'s purse. The New Jersey Supreme Court agreed with the lower courts that the Fourth Amendment applies to searches conducted by school officials. The court also rejected the state of New Jersey's argument that the exclusionary rule should not be employed to prevent the use in juvenile proceedings of evidence unlawfully seized by school officials. Declined to consider whether applying the rule to the fruits of searches by school officials would have any deterrent rule value. The court held simply that The precedents of this court established that if an official search violates constitutional rights, the evidence is not admissible in criminal proceedings. With respect to the question of the legality of the search before it, the court agreed with the juvenile court that a warrantless search by a school official does not violate the Fourth Amendment so long as the official has reasonable grounds to believe the student possesses evidence of illegal activity or activity that would interfere with school discipline and order. However, the court, with 2 justices dissenting, simply disagreed with the juvenile court's conclusion that the search of the purse was reasonable. So there are 2 dissenters. According to the majority, the contents of T.L.O's purse had no bearing on the accusation against T.L.O for possession of cigarettes, as opposed to smoking them in the laboratory. Did not violate the rules, and a mere desire for evidence that would impeach T.L.O's claim that she did not smoke cigarettes could not justify the search. Moreover, even if a reasonable suspicion that T.L.O had cigarettes in her purse would justify a search, Mr. Choplick had no such suspicion, and no one had furnished him with any specific information that there were cigarettes in the purse. Finally, leaving aside the question whether Mr. Choplick was justified in opening the purse, the court held that the evidence of drug use that he saw inside did not justify the extensive rummaging through T.L.O's papers and effects that followed.
They're getting down to the nitty-gritty now, searching purses and cigarettes.
So 7-day suspension was set aside by the Court of New Jersey Chancery Division. The Board of Education apparently did not appeal the decision. So, as it pertains to her school suspension, they reached a different result than the Supreme Court did. So we granted the state of New Jersey's petition for cert, although the state had argued in the Supreme Court of New Jersey that the search of T.L.O's purse did not violate the Fourth Amendment. The petition for certiorari raised only the question whether the exclusionary rule should operate to bar consideration in juvenile delinquency proceedings of evidence lawfully seized by a school official without the involvement of law enforcement officers. When this case was first argued last term, the state conceded for the purpose of argument that the standard devised by the New Jersey Supreme Court for determining the legality of school searches was appropriate and that the court had correctly applied the standard. The state contended only that the remedial purposes of the exclusionary rule were not well served by applying it to searches conducted by public authorities, not primarily engaged in law enforcement. Although we originally granted certiorari to decide the issue of the appropriate remedy in juvenile court proceedings for unlawful school searches, our doubts regarding the wisdom of deciding that question in isolation from the broader question of what limits, if any, the Fourth Amendment places on the activities of school authorities prompted us to order re-argument on that question. Having heard argument on the legality of the search of T.L.O's purse, we are satisfied that the search did not violate the Fourth Amendment. In determining whether the search at issue in this case violated the Fourth Amendment, we are faced initially with the question whether that Fourth Amendment's prohibition on unreasonable searches and seizures applies to seizures conducted by public officials. We hold that it does. So I don't know. Is this quite? There's like many questions. I'm going to call this question 1. It is now beyond dispute that the federal Constitution, by virtue of the 14th Amendment, prohibits unreasonable searches and seizures by state officers. Equally indisputable is the proposition that the 14th Amendment protects the rights of students against encroachment by public school officials. These two propositions, that the Fourth Amendment applies to the states through the 14th Amendment and that the actions of public school officials are not subject to the limits placed on state action by the 14th Amendment, might appear sufficient to answer the suggestion that the Fourth Amendment does not prescribe unreasonable searches by school officials. This could also be factor 1. Factor 1, can you? Factor 2, did you do it reasonably? We'll see. might appear sufficient to answer the suggestion that the Fourth Amendment does not prescribe unreasonable searches by school officials. On re-argument, however, the state of New Jersey has argued that the history of the Fourth Amendment indicates that legislative history was intended to regulate only searches and seizures carried out by law enforcement officials. Accordingly, although public school officials are conceivably state agents for purposes of the 14th Amendment, the Fourth Amendment creates no rights enforceable against them. This court has never limited the amendment's prohibition on unreasonable searches and seizures to operations conducted by the police. Rather, the court has long spoken of the Fourth Amendment's strictures as restraints imposed upon governmental action, that is, upon the activities of sovereign authority. Accordingly, we have held the Fourth Amendment applicable to the activities of civil as well as criminal authorities, building inspectors, inspectors, and even firemen entering privately owned premises to battle fire are all subject to the restraints imposed by the Fourth Amendment. We have held school officials subject to the commands of the Fourth Amendment and the Due Process Clause of the 14th Amendment. If the school authorities are state actors for purposes of constitutional guarantees of freedom of expression and due process, it is difficult to understand why they should be deemed to be exercising parental rather than public authority when conducting searches of their students. More generally, the court has recognized that. So this is kind of a comparison, I guess. Comparing to freedom of expression. More generally, the court has recognized the concept of parental delegation as a source of school authority is not entirely consonant with compulsory education laws. Today's public school officials do not merely exercise authority voluntarily conferred on them by the individual parents. Rather, they act in furtherance of publicly mandated educational and disciplinary policies. So it's not a consensual delegation if attendance is mandatory. What about homeschooling? And what if this happened in a private school? Today's public school officials do not merely exercise authority voluntarily conferred on them by the parents. Rather, they act in furtherance of policy-mandated educational and disciplinary policies. In carrying out searches and other disciplinary functions pursuant to such policies, school officials act as representatives of the state, not merely as surrogates for the parents, and they cannot claim the parents' immunity from the strictures of the Fourth Amendment. To hold that the Fourth Amendment applies to searches conducted by school authorities is only to begin an inquiry into the standards governing such searches. Although the underlying command of the Fourth Amendment is always that searches and seizures be reasonable, what is reasonable depends on the context within which a search takes place. The determination of a standard of reasonableness governing any specific class of searches requires balancing the need to search against the invasion of the search entails. So this is the test. And on one side of the balance are arrayed the individual's legitimate expectations of privacy and personal security. On the other is the government's need for effective methods to deal with breaches of public order. So we have recognized that even a limited search of the person is a substantial invasion of privacy from Terry v. Ohio, 1967. We have also recognized that searches of closed items of personal luggage are intrusions on protected privacy interests. For the Fourth Amendment, okay, so the search of the person and luggage. The Fourth Amendment provides protection to the owner of every container that conceals its contents from plain view. United States v. Ross, 1982. A search of a child's person or a closed purse or other bag carried on her person no less than a similar search carried out by an adult is undoubtedly a severe violation on the subjective expectations of privacy. Like 4 more pages of this. Of course, the Fourth Amendment does not protect subjective expectations of privacy that are unreasonable or otherwise illegitimate. To receive the protection of the Fourth Amendment as expectation of privacy must be one that society is prepared to recognize as legitimate. The state of New Jersey has argued that because of the pervasive supervision to which children in schools are necessarily subjected, a child has virtually no legitimate expectation of privacy in articles of personal property unnecessarily carried into school. No privacy expectation. This argument has 2 factual premises. 1, the fundamental compatibility of expectations of privacy with the maintenance of a sound educational environment, and 2, the minimal interest of the child in bringing any items of personal property into a school. Both premises are severely flawed. Although this court may take notice of the difficulty of maintaining discipline in public schools today, the situation is not so dire that students in the schools may claim no legitimate expectations of privacy. We have recently recognized that the need to maintain order in a prison is such that prisoners retain no legitimate expectations of the privacy in their cells, but it goes almost without saying a prisoner and a school child stand in wholly different circumstances separated by the harsh facts of criminal conviction and incarceration. We are not yet ready to hold that the schools and the prisons need to be equated for the purposes of the Fourth Amendment, even though there is a higher deference in other cases, which I assume we're going to skip over. Nor does the state's suggestion that children have no legitimate need to bring personal property into the schools seem well anchored in reality. Students at a minimum must bring to school not only the supplies needed for their studies, but also keys, money, and the necessaries of personal hygiene and grooming. In addition, students must carry on their persons or purses or wallets such non-disruptive yet highly personal items as photographs, letters, and diaries. Finally, students may have perfectly legitimate reasons to carry with them articles of property needed in connection with extracurricular or recreational activities. In short, school children may find it necessary to carry with them a variety of legitimate non-contraband items, and there is no reason to conclude that they have necessarily waived all rights to privacy in such items merely by bringing them onto school grounds. Against a child's interest in privacy must be set the substantial interest of teachers and administrators in maintaining discipline in the classroom and on school grounds. Maintaining order in the classroom has never been easy, but in recent years, school disorder has often taken particularly ugly forms. Drug use, violent crimes have become major social problems, even in schools that have been spared the most severe disciplinary problems. The preservation of order and a proper educational environment requires the close supervision of school children as well as the enforcement of rules against conduct that would be perfectly permissible if undertaken by an adult. Events calling for discipline are frequent occurrences and sometimes require immediate, effective action. Accordingly, we have recognized that maintaining security and order in the schools requires a certain degree of flexibility in school disciplinary procedures, and we have respected the value of preserving the informality of the teacher-student relationship. Preserving that relationship. How then Should we strike the balance between the school child's legitimate expectation of privacy and the school's equally legitimate need to maintain an environment in which learning can take place? It is evident that the school setting requires some easing of the restrictions to which searches by public authorities are ordinarily subject. The warrant requirement in particular is unsuited to the school environment. Requiring a teacher to obtain a warrant before searching a school suspected of an infraction of school rules or of the criminal law would unduly interfere with the maintenance of a swift and informal disciplinary procedures needed in the schools, just as we have in other cases dispensed with the warrant requirement when the burden of obtaining a warrant is likely to frustrate the governmental purpose of the search. We hold today that school officials need not obtain a warrant before searching a student who is under their authority. So that's their holding, and it should be. The school setting also requires some modification of the level of suspicion of illicit activity needed to justify the search. Ordinarily, a search, even one that may permissibly be carried out without a warrant, must be based on probable cause to believe that a violation of law has occurred. However, probable cause is not an irreducible requirement of a valid search. The fundamental command of the Fourth Amendment is that searches and seizures be reasonable, and although both the concept of probable cause and the requirement of a warrant bear on the reasonableness of the search, in limited circumstances, whether neither is required. Thus, we have a number of cases recognize the legality of searches and seizures based on suspicions that, although reasonable, do not rise to the level of probable cause. Where a careful balancing governmental and private interest suggests that the public interest is best served by the Fourth Amendment standard of reasonableness that stops short of probable cause, we have not hesitated to adopt such a standard. We join the majority of the courts that have examined the issue and concluding that the accommodation of the privacy interests of school children with the substantial need of teachers and administrators for freedom to maintain order in the schools does not require strict adherence to the requirement that searches be based on probable cause, to believe that the subject of the search has violated or is violating the law. Rather, the legality of the search of the student should depend simply on the reasonableness under the circumstances of the search. Determining the reasonableness of any search involves a twofold inquiry. First, reasonableness test one. First, one must consider whether the action was justified at the inception. Second, one must determine whether the search actually conducted was reasonably related in scope to the circumstances in which justified the interference in the first place. Under ordinary circumstances, a search of a student by a teacher or a school official will be justified at its inception when there are reasonable grounds for suspecting that the search will turn up evidence that the student has violated or is violating either the law or the rules of the school. Such a search will be permissible in its scope when the measures adopted are reasonably related to the objectives of... Okay, so there's a footnote that brings us to Pitcha versus Whale Blues. Don't care. Search and not so. Objectives of search and not excessively intrusive in light of the age and sex of the student and the nature of the infraction. This standard will, we trust, neither unduly burden the efforts of school authorities to maintain order in their schools nor authorize unrestrained intrusions upon the privacy of school children. So they're striking a balance. By focusing attention on the question of reasonableness, the standard will spare teachers and and school administrators the necessity of schooling themselves and the niceties of probable cause and permit them to regulate their conduct according to the dictates of reason and common sense. At the same time, the reasonableness standard should ensure that the interests of students will be invaded no more than is necessary to achieve the legitimate end of preserving order in the schools. There remains the question of the legality of the search in this case. We recognize that the reasonable ground standard applied by the New Jersey Supreme Court in its consideration of the question is not substantially different from the standard that we adopt today. Nonetheless, we believe that New Jersey Court's application of that standard to strike down the search of T.L.O.'s purse reflects a somewhat crabbed notion of reasonableness. Our review of the facts surrounding the search lead us to conclude that the search was in no sense unreasonable for Fourth Amendment purposes. The New Jersey Supreme Court pointed to two grounds for its holding. So I want to say the Supreme Court didn't look at, totality of circumstances, I guess. They only looked at the invasion. They didn't look at the grounds for it. So pointed to two grounds. That is, the New Jersey Supreme Court pointed to two grounds for its holding that the search for cigarettes was unreasonable. First, the court observed that possession of cigarettes was not in itself illegal or violation of school rules because the contents of T.L.O.'s purse would therefore have no direct bearing on the infraction of which she was accused, smoking in a lavatory where smoking was prohibited. There was no reason to search her purse. Second, even assuming that the search of T.L.O.'s purse might, under some circumstances, be reasonable in light of the accusation made against T.L.O., the New Jersey court concluded that Mr. Choplik, in this particular case, had no reasonable grounds to suspect that T.L.O. had cigarettes in her purse. At best, according to the court, Mr. Choplik had a good hunch. Okay, so that's all wrong. He did have reason to believe that there were cigarettes there, but if that's not a violation of school rules, that's a different story. So both these conclusions are implausible. T.L.O. had been accused of smoking and had denied the accusation in the strongest possible terms when she stated that she had smoked at all. Surely it cannot be said that under these circumstances, T.L.O.'s possession of cigarettes would be irrelevant to the charges against her or to her response to those charges. T.L.O.'s possession of cigarettes, once it was discovered, would both corroborate the report that she had been smoking and undermine the credibility of her defense to the charge of smoking. The relevance of T.L.O.'s possession of cigarettes to the question of whether she had been smoking and to the credibility of her denial that she smoked supplied the necessary nexus between the item searched for and the infraction under investigation. Thus, if Mr. Choplik in fact had a reasonable suspicion that T.L.O. had cigarettes in her purse, the search was justified, despite the fact that cigarettes, if found, would constitute mere evidence of a violation. Because there's a violation, apparently, unlike what the Supreme Court of New Jersey saw. So, of course, the New Jersey Supreme Court also held that Mr. Choplik had no reasonable suspicion that the purse would contain cigarettes. This conclusion is puzzling. The teacher had reported that T.L.O. was smoking in the lavatory. Certainly, this report gave Mr. Choplik reason to suspect that T.L.O. was carrying cigarettes with her, and if she did have cigarettes, her purse was the obvious place in which to find them. The requirement of reasonable suspicion is not a requirement of absolute certainty. Sufficient probability, not certainty, is the touchstone of reasonableness under the Fourth Amendment. Because, so here they just basically take apart the reasoning of the Supreme Court. Because the hypothesis that T.L.O. was carrying cigarettes in her purse was itself not unreasonable, it is irrelevant that other hypotheses were also consistent with the teacher's accusation. Accordingly, it cannot be said that Mr. Choplik acted unreasonably when he examined T.L.O.'s purse to see if it contained cigarettes. Our conclusion that Choplik's decision to open T.L.O.'s purse was reasonable brings us to the question of further search for marijuana once the pack of cigarettes was located. The suspicion upon which the search for marijuana was founded was provided when Mr. Choplik observed a package of rolling papers in the purse as he removed the pack of cigarettes. Although T.L.O. does not dispute the reasonableness of Choplik's belief that the rolling papers indicated the presence of marijuana, she does contend the purpose of the search Mr. Choplik conducted exceeded permissible bounds when he seized and read certain letters that implicated T.L.O.'s drug dealing. This argument, too, is unpersuasive. The discovery of rolling papers conceivably gave rise to reasonable suspicion that T.L.O. was carrying marijuana as well as cigarettes in her purse. This suspicion justified further exploration into the purse, which turned up more evidence of drug-related activities. A pipe, a number of plastic bags, and of the type commonly used to store marijuana, a small quantity of marijuana, and a fairly substantial amount of money. Under these circumstances, it was not unreasonable to extend the search to a separate zippered compartment of the purse, and when the search of that compartment revealed an index card containing a list of people who owe me money, as well as 2 letters, the inference that T.L.O. was involved in marijuana trafficking was substantial enough to justify Mr. Triplett in examining the letters to determine whether they contained further evidence. In short, we cannot conclude that the search for marijuana was unreasonable in any respect, because the search resulting in the discovery of the evidence of marijuana dealing by T.L.O. was reasonable. The New Jersey Supreme Court decision to exclude that evidence from T.L.O.'s juvenile delinquency proceedings on Fourth Amendment grounds was erroneous. Accordingly, the judgment is reversed. So Powell and Justice O'Connor concur, and Brennan and Marshall concur in part. Blackman concurs, and I just want to figure out where Ginsburg is on this because I know she disagrees. Stevens and Marshall joins, with whom Brennan joins, concurring in part, dissenting in part. And okay, so we left out Ginsburg harebrained ideas in this dissenting opinion. Maybe she just was sick that day. I think 6 pages of dissenting opinion is a bit too long for this recording, so I'm going to skip.